May it please the court, R.D. Norris for appellant plaintiff, Mr. Holmes, and I'd like to reserve 5 minutes. If possible.
5 minutes? All right.
This case is essentially about a expert disclosure.
Would you pull that microphone back to you, please?
Yes, sir. Sorry
I have
about
a little difficulty hearing. There you go. Thank you.
This case is essentially about expert disclosures. This case presents an opportunity for this court to give the appellant an opportunity to pursue justice based on the merits of this case and reverse the severe punishment inflicted by the trial court solely due to excusable neglect of the appellate attorney. Appellant was denied this opportunity, however, when the trial court incorrectly denied Mr. Holmes' motion to amend the scheduling order and allow for a time to disclose complete expert discovery. Although counsel did miss the expert disclosures deadline, Mr. Holmes' counsel did file an expert disclosures and explained what the mistake he made in interpreting the scheduling order as to why there was a delay. And this was only a 28-day delay in missing the deadline. When the trial court evaluated whether to grant the enlargement, the court must take 4 factors into consideration: whether risk of prejudice to the parties opposing the late filing, delay and its potential impact on the proceeding, reasons why the filing was late, and whether the reasons followers in reasonable filer's control, and good or bad faith on the filer. The untimeliness of the expert's disclosures did not disrupt the trial date, and the only prejudice the defendant was minimal inconvenience of moving back the expert disclosure deadline and having to move their deadline. There was no bad faith. Even the trial court explained that this was saw that it was an inadvertent mistake on counsel's part, and there was no bad faith for the delay. Even though there was only a nominal, if any, prejudice to Mr. Shipp, and there would be no delay in trial date due to excusable neglect of the counsel's late disclosure, the trial court inflicted the harshest sanctions possible and denied Mr. Holmes the ability to pursue justice based on the merits of his claim. Because the trial court abused its discretion when denying the plaintiff's motion to amend the scheduling order, a plaintiff requests this court to reverse the denial of the motion to amend the scheduling order and reverse the court's reverse the court's grant of the defendant's motion for summary judgment. And if you have any questions, that's really all I have.
Thank you.
Yeah.
Good afternoon, Your Honors. May it please the court. I'm Will Podesta with Lewis Thomason in Memphis, and along with Margaret Cooper-Roney represent the appellee defendant, Mr. Stacy Shipp. There are 2 issues on appeal. First, the denial of the plaintiff's motion to amend the scheduling order, and second, the grant of a motion for summary judgment. And this court should affirm the trial court in all respects. I will start with that first issue. The standard of review regarding an enlargement of time is abuse of discretion. There's an abuse of discretion only when the trial court applies an incorrect legal standard or applies a standard illogically, unreasonably, and in a way that would cause an injustice. There is no argument that the trial court applied the wrong legal standard, and so in order for the appellant to meet his, the time is not counting down.
Do what? I'm sorry. Oh, I'm sorry. I was coughing.
In order for the appellant to meet his burden of establishing an abuse of discretion, he must establish that the trial court acted incorrectly or held incorrectly in that they were unreasonable, illogical, and that caused an injustice to him. He is not going to be able to meet that burden because the trial court's conclusion was both logical and reasonable. Mr. Norris touched on the factors for excusable neglect. Excusable neglect was a requirement here, or the appellant establishing excusable neglect was a requirement because the motion for the enlargement was not made until well after that deadline was missed. Generally, neglect is inexcusable when that neglect was fully within that party's control, and even faultless errors, faultless omissions can constitute inexcusable neglect.
Was an affidavit filed about the delay or the reason for not complying with the scheduling deadline?
No, Your Honor. There was no proof in the record in that respect. There were statements from counsel in motions, but no facts in the record in that respect.
Can the court consider just statements?
I believe the court can consider statements in the context of a motion before the court, but even if the court is unable to consider those statements of counsel, that would leave the appellant with no basis for his extension, no proof in the record as to why that should be granted.
Well, what I'm trying to get to is an affidavit required in those types of situations?
I don't believe so, Your Honor. I'll be candid. I didn't look at that issue closely. However, generally, I would not say so. I did not see in the case law or rules of procedure that that would be a requirement.
Well, did you or your client consent to the fact or agree that the reason the scheduling order was not complied with was based on what opposing counsel said to the court?
Not precisely, Your Honor. We don't oppose the fact that there was some calendaring error on the part of appellant's counsel. We do strongly oppose the overtures made in the motion that the scheduling order was somehow ambiguous or unclear. The scheduling order, the specific paragraph is very clear as to what that deadline was speaking to. It states, plaintiff shall produce any and all experts to be used at trial, including treating physicians, for a deposition, for discovery, or for evidence on or before February 10th, 2023. In the plaintiff's motion to amend the scheduling order, he dropped the language for a deposition, for discovery, or for evidence, and replaced it with an ellipsis, a very tactical use of ellipsis. Of course, when the word deposition is removed from the sentence, it's less clear that that sentence is concerning a deposition. However, it is quite clear in the scheduling order, and this is typical form language that's used in scheduling orders, that it was clear, and the trial court made that finding. What's more, Your Honor, the appellant's counsel agreed to this scheduling order before it was entered. If there was some ambiguity about what was required, that should have been raised before it was agreed to and before the court entered it. And so on those 2 points, Your Honor, we dispute that the scheduling order was somehow confusing. And that goes to the reason for the missed deadline, which is the most important of the factors in this analysis. There are 2 sort of considerations within that: whether that neglect was under the movement's control and whether the movement was paying appropriate attention.
Let me ask you this. Had there even been a disclosure there was another date that preceded the date for the presenting for a deposition. There was a January 6, 2023 date for disclosure. Did the disclosure even occur?
No, Your Honor, and that is the missed deadline. It's the disclosure deadline that was missed.
Okay, that's not what you were reading from, though, was it?
That's a good point, Your Honor. The appellant's position was that the language that I just read was confusing as to whether it spoke to a disclosure deadline or a deposition deadline. His point was that he read it to speak to a disclosure deadline, which is why he did not make any disclosures at the January 6th deadline. He waited till February 10th, which was clearly a deposition deadline. Generally, in Tennessee law, they're sort of well established that a calendaring error does not constitute excusable neglect. I've cited, I believe, 4 cases in my brief for that proposition, and certainly the trial court's conclusion that was in concert with these appellate cases from Tennessee was not illogical or unreasonable. going to the lack of appropriate attention, the confusion, this purported confusion with the scheduling order can really only result from a lack of attention to what the words on the page are. This lack of attention is further illustrated by the appellant not moving for an enlargement of this deadline until 3.5 weeks after the deadline had passed, and until 2 weeks after I noted in the record that that deadline had passed. Frankly, the procedural history of this case shows a long pattern of neglect, and I'd like to be careful to note that I'm not speaking to Mr. Norris. He was not involved in this case until the appeal, but he is the 9th attorney who has represented the plaintiff in this case, and that high level of turnover led to a lack of attention. For example, the plaintiff failed to serve the defendant Elite Towing and Transport, never reissued that summons. That defendant has now been dismissed. The second co-defendant, Ian Goodman, was never served. A summons was never reissued for him. The claims against him are now time barred. The appellant didn't depose Mr. Shipp, the appellee, until 3 years into this case and several years after he had Mr. Shipp's written discovery responses. And this may be sort of a small point, but I think it's indicative that throughout the briefing, appellant refers to Mr. Shipp as Miss Shipp. Mr. Shipp, this case has been going on for the better part of a decade. Mr. Shipp has been deposed. Mr. Shipp has produced his driver's license. The only explanation for appellant not knowing his gender is a lack of attention to this case. Because this delay was entirely within the neglect was entirely within the appellant's control and resulted from a lack of appropriate attention, the trial court was both logical and reasonable in weighing this factor in favor of the appellee. Moving to prejudice, the appellee would have been severely prejudiced by the proposed extensions in that it would severely limit the ability to generate rebuttal expert proof. In his motion, the plaintiff proposed that the deadline for plaintiff's disclosures be pushed out 12 weeks from when they were originally set. The deadline for plaintiff's depositions, the expert depositions, be pushed out 7 weeks. But in order to be able to keep this same trial date, we are going to shorten the window for defendant's expert depositions from 6 weeks to 2 weeks. And so that means within 2 weeks of the plaintiff's expert being deposed, the defendant had to get that transcript, get it to the experts, have them review it and formulate opinions, prepare them for a deposition, and then produce them for a deposition, all while crossing our fingers that that expert had availability within that very short window. It also, the proposed extension flipped the order of expert proof such that the defendant would be required to disclose rebuttal expert proof before the medical proof had been taken. And then finally, it allows only for supplementation of appellant's expert disclosures to the exclusion of appellee's expert disclosures. So all of those things would severely limit the appellee's ability to generate rebuttal proof. And contrary to the appellant's statement, in order for the trial court to grant this extension in some way that would not have caused this prejudice, the trial date would have had to have been extended. There was simply not enough time before this June trial date to do all of the pretrial things that needed to be done, motions and trial prep and things, after those deposition deadlines were bumped back to where they would have been bumped back to. And so after years of inaction in this case and bearing the stress of this case for the better part of a decade, Mr. Shipp would have had to wait even longer. And so 3 of those 4 factors weigh strongly in favor of the trial court's decision. The fact that the trial court didn't find evidence of bad faith does not render the court's conclusion illogical or unreasonable.
I know you've just gone through those analysis of the factors. Did the trial court do that?
Yes, Your Honor. In the trial court, the ordering language is clear. There are times where the trial...
Did the trial court hold a hearing and do that, or are you relying upon the language in the order.
Relying on, in the language of the order, there was no hearing here, Your Honor, and that was something that the parties were aware this was going to be heard on briefs only pursuant to this trial court's procedures. And even with that knowledge, the plaintiff filed a motion that was threadbare. And so setting aside the factors, it's important to consider what the trial court had before it for adjudication. The plaintiff sets forth basically one paragraph in the motion, doesn't set forth the standard, doesn't set forth a legal argument that entitles him to the relief sought, and did not file a reply brief, which he had a right to do. The trial court was weighing that against appellant's brief, appellee's brief, which did set forth a standard and set forth a legal argument. And so the trial court is weighing a motion that does not set forth a legal argument entitling the movement to relief against a response in opposition that sets forth a legal argument that establishes that the relief sought is not, that the plaintiff is not entitled to that relief.
So you're saying the trial court did all that analysis you just did in its March 1, 2023 order?
Yes, Your Honor, maybe not in as many words. However, she certainly does, and sometimes doesn't use the exact language from the case law. For instance, she says, I believe that this error was inadvertent, as opposed to saying there was no bad faith.
Trial court does say that.
Yes, Your Honor.
Trial court says plaintiff's not met his burden of proving that excusable neglect as a scheduling order, and says why there. And then says, as the plaintiff's error was in plaintiff's control and amounts to a calendar error by plaintiff's own admission, court denies the motion and says that the error was inadvertent.
Yes, Your Honor, and I think the court.
I don't think that's those four factors we talked about.
I think the court also strongly relied on the cases cited in the motions and in the briefing, where Tennessee courts have held that a mere scheduling error does not constitute excusable neglect.
Court didn't say that either, did it?
No, Your Honor, not in as many words. However, it does reference that the scheduling order does not meet excusable neglect.
Did say that.
And so, to respond to a few of the plaintiff's arguments, the argument regarding the trial court levying too harsh of a sanction or punishment, there was no sanction or punishment here. The denial of a motion to enlarge time is not a sanction or punishment. The grant of summary judgment is not a sanction or punishment. The court considered each of those motions separately and applied the appropriate factors in reaching its conclusions. And then finally, in response to the argument that the trial court somehow robbed the plaintiff of an opportunity to seek justice, I would just note that that opportunity is unadulterated and that the plaintiff is not without recourse here. And unless the court has additional questions.
Thank you. No.
On behalf of Mr. Shipp, thank you very much.
So, counsel, do you have to file an affidavit with your motion?
I don't know what happened prior to me taking on the case, Your Honor.
I understand. I did not realize you weren't.
I got the case after some motion for summary judgment. I'll sign the case, and I apologize.
Let me tell you what my problem is. I'm looking at Rule 6.02, enlargement. And it says, essentially, the court, for cause shown, may at any time in its discretion enlarge. So, how does the court find cause here if there's no affidavit or no testimony or anything?
I could only assume the previous attorney or the prior attorney that filed the motion to amend the order and the motion to...
I'm not being critical of you or the prior attorney. I'm just trying to sort this out in my mind.
I could only assume that that's what was in his mind, and for Your Honor, that he did put in that motion the reason why he thought he got confused with his calendar and he made the calendar error. That's the only thing I could think of. I don't know why there wasn't
Well, let me ask you a second question. Opposing counsel has said that the court properly analyzed these, I think, the Williams factors. I'm looking at this order on a motion for summary judgment, and I'm not seeing the analysis that the court did.
Yep.
Is that error? And if so, was the court required to do that?
Absolutely, Your Honor. I believe that's the basis on our appeal. The court didn't find factors, didn't lay out the factors for it clearly in the order, which made us guess, and we could only assume that the court did her due diligence, but it didn't reflect in her order.
Here's my problem with that. You look at Rule 54.02, I believe. The court's only required to make findings of fact and conclusions of law at bench trials and other specified situations. Motions aren't necessarily part of those situations. So how do you extrapolate that from your position to where we are?
That's a good question, Your Honor.
I think it's 54.02.
I got to admit, I'm not read up on that rule, and I apologize. I think Mr. Podesta hit the nail right on the head, and what it ultimately comes down to, and the abuse of discretion.
52.01, excuse me.
52.0. It ultimately comes down to the court failed to adequately use its analysis, and it resulted in unreasonable injustice. It's ultimately the unreasonable injustice, and it was sanctions because of the motion for summary judgment that was granted, because of the denial of the amended scheduling order. It's essentially killed the case for Mr. Holmes. And Mr. Podesta did point out that previous attorneys made some errors, and there was lots of inefficiencies in this case. Again, I can't speak to any of that. And thank you for pointing out that I failed to properly gender Mr. Shipp. And again, but that is no indication that this really comes down to unreasonable injustice on part of the decision made, which essentially failed to give Mr. Holmes a right to get his case heard on the merits of his case. Mr. Podesta does cite 4 cases. In two of those four cases, the appellant had an opportunity still to be heard on the merits of his case. On the other 2 cases, the unexcusable neglect was so flagrant that that's why the court found in favor of the mover, as opposed to for the appellant. One was completely missed trial, even though after several notices of trial dates, and the other one completely didn't respond to a counter complaint a year after. This was a mere 28 days late in disclosing experts, a mistake. No doubt it might have had something to do with the 9 attorneys that Mr. Podesta pointed out, and there was mistakes made in this case prior. But all the more reason Mr. Holmes shouldn't be punished unreasonably and unjustly. Thank you, Your Honor.
Thank you. Thank you, counsel. We'll take this matter under advisement and attempt to render an opinion as quickly as possible. You may be excused.